thank you everyone for coming, and for those of you who are not students at the law school, welcome to the University of New Hampshire School of Law. I'm Roger Ford. I'm on the faculty here at the law school. I teach intellectual property and privacy law. And I'm really looking forward to what I think is going to be a fascinating conversation today. So this event really grew out of two rather remarkable events that happened in the last year. So the first was the Sony hack, which happened at the end of 2014, where someone, apparently the North Korean government, infiltrated Sony Pictures' computer systems and gathered up a bunch of data and basically released it to the world. Everything from scripts to salary information to internal emails to pre-release copies of movies, health information, copies of passports. All in all, more than 100 terabytes of data that they just put on the internet for anyone to download. And a lot of this information was understandably very sensitive. So Sony was badly damaged by these leaks. A lot of it was dirt that was attractive to the tabloids. So things like there was a producer who called Angelina Jolie a minimally talented, spoiled brat. There were executives making racist comments about the president. But then there were also things like the social security numbers and health insurance information of the employees of Sony Pictures, some of the stars of movies that Sony had released. And then the other event that happened was the Houston Astros hack earlier this year. And in that one, it sort of began when the blog Deadspin posted a story with the headline, "Leaked, 10 months of Houston Astros internal trade talks." And that seems bad enough, but it really understated what had happened. So, like a lot of teams in professional sports in the last few years, the Astros make very extensive use of statistical analytics to make their decisions about things like player signings, draft picks, strategies to use against opponents. And the Astros stored a lot of this information, maybe all of this information, in this one database. And it turns out that employees of the St. Louis Cardinals, a competing team, had been accessing that database and then leaked it to this anonymous site on the internet, and then Deadspin picked it up. And so we could imagine that harming the Astros in various ways, but we could also think that if teams like the Cardinals were using this information in competitive ways to make their own decisions, to plan against the Astros or to know what the maximum they could get in a trade was, that might be a very significant competitive advantage for another team. And so this is obviously not a problem that's limited to sports or entertainment. You've probably seen stories about credit card data breaches. I have one card, for instance, that's been replaced by the bank 3 times because it was part of the Home Depot data breach and the Target data breach and the Staples data breach. And that's costing these banks a lot of money. And then even companies that you would expect to be really careful about this kind of thing have been hacked. So Anthem, a health insurance company, one of the biggest in the country, lost 80 million customers' healthcare information. And there was a story in Wired a few weeks ago about hackers who were able to gain remote control of an SUV, where they could turn the stereo on full blast, or they could turn the heat on, or the wipers on, and that becomes a real safety problem. So this really goes beyond things like entertaining stories about movie stars and really becomes a safety issue for a lot of people. And so as more and more things are running on computers like cars, which we didn't normally think of as a computerized device, and as companies have more and more of this kind of information, companies have had to take steps to protect users and to protect themselves. And all of these companies have really involuntarily found themselves in the security business in a way that wasn't true 5 or 10 or 20 years ago. And it's not really their core competency, so they're really having to learn from the ground floor. So today I think we're going to discuss how this dynamic plays out in sports and entertainment, and what companies and teams can do to respond to these threats, how they can plan for them. And to do that, we have really what I think is an all-star, no pun intended, panel, and I'd like to introduce them. So first, to my left, Mark Szpak?
Szpak.
Szpak,
Mark
thank
Szpak.
you. He's a partner at Ropes & Gray. He's a member of the firm's data breach and privacy practice group, which is one of the leading practice groups in really an exploding practice area. He's represented numerous clients in privacy and data security matters, like the Home Depot, Sony, Neiman Marcus, Wyndham Hotels, and he's been a litigator for more than 30 years practicing in that area and a bunch of other areas. Second, we have Mandy Petrillo, who's Director of Legal Operations at the Boston Red Sox and Fenway Sports Management. Mandy works on everything from corporate deals to sponsorship agreements to the acquisition of the Liverpool Football Club. And it turns out one of the great perks of working for a group like the Red Sox is she has a World Series ring from 2013, which I think is really cool.
I did not bring.
Which you did not bring.
Sorry.
You didn't bring one for everyone? Come on. Third, Sean Smith is a professor of computer science at Dartmouth. He runs the Dartmouth Trust Lab and is director of the Institute for Security, Technology, and Society. And his research focuses on information security and investigating ways to build trustworthy systems. He's worked on security for everything from secure microprocessors to postal meter fraud. And then finally, we have Bob Ryan, who's a legendary sports writer in the Boston area and nationally. He's written for the Boston Globe for more than 40 years, covering dozens of NBA Finals, Final Fours, World Series, Super Bowls, been to 7 Olympic Games, numerous other sporting events. He's also a regular commentator on ESPN and has won many awards, including the National Sports Writer of the Year Award, which he's won 4 times from the National Sportscasters and Sports Writers Association. So please welcome our panel. And the way we're going to do this is I'm going to give each of them 5 minutes or so to give an introduction, sort of explain their take on this topic, how it comes up in their practice and their business. And then we'll launch into a discussion. We'll also take questions from the audience. There will be members of the Sports and Entertainment Law Society with note cards that you can write questions on that I can then read. That'll make it easier for the cameras. So take it away, Mark.
Well, thanks very much, Professor Ford, and thanks to everybody for being here. I have to say it's really an honor to be on a panel with these other panelists here. And it's very exciting for me to be here. I'm from Ropes and Gray in Boston, but I was born and bred here in New Hampshire. I don't know if anybody here is from Manchester, but I'm a St. Casimir school guy, and I went to Manchester High School Central, so to be able to be here and do this is just terrific for me. I took the Mass Bar in the summer of 1985 and started at Ropes and Gray that fall, but nonetheless, the following summer, I took 2 weeks off and took the New Hampshire Bar. So I'm actually a member of the New Hampshire Bar. My bar number is 2507, which is very low. And I think the Bar Association knows at least my name because they've made a fortune off of the late fees and fines that I've paid for not getting my CLE training certificate in on time. So I'm getting CLE credit for this. I just want to say that right. I've been a litigator since '85, and I've worked on all kinds of matters, including some in New Hampshire. Took advantage of the New Hampshire Bar membership. I've done securities class actions. I got a 10b-5 case for timberland dismissed years ago. I worked on tax disputes. One of my favorite cases of all time is when we had a client, we challenged the constitutionality of the New Hampshire business profits tax. And ultimately it was settled. I tell people that the fiscal stability of the state can be attributed to the fact that we were willing to settle that case. And I worked on franchise litigation. I've probably sued or defended every Mercedes-Benz franchise in northeastern Massachusetts, including one in New Hampshire. But I've also worked on consumer class actions, bankruptcy, non-competes, trademark disputes. Alex Roberts, you was at Ropes and Gray. You all are so lucky to have her here. We are so unlucky to have lost her to you. But she worked on trademark matters with me way back when. And I worked on trade secret and patent litigation. The trade secret part of it is sort of relevant to what we're doing here today to some extent. The big trade secret case I worked on is that we represented Reebok in a dispute over who invented the pump sneaker. if any of you remember the
Oh,
pump
yeah.
sneaker.
Absolutely.
I know exactly what happened. I can't tell you, but it's a great case. And the trade secret law that I learned there, it comes to mind all the time when I work on these cases. But since 2007, I've worked mostly on these large data breaches. Late December 1986, we got a call from one of our longtime established clients, TJX. TJX had an issue, and the newspapers report that it involved 40 million or more credit card numbers, and there really had been no case like it before, and it turned into, so we handled that soup to nuts, all fronts, and it turned into the first of what has seemed like a never-ending stream of large data breaches involving credit cards and personal information. Because of our experience in that first case, we were hired again, the next big case that came around, and it's happened quite a bit since then. So we worked on a case involving Heartland Payment Systems. Newspapers there said that involved 70 million credit cards. When I got back to the office one night and saw that Sony PlayStation had been hacked, I sent an email in, and we were hired within a couple days, and I spent a month sitting with the forensic examiners at Sony PlayStation working on that case. That was 110 million records according to the newspapers, and it really was a worldwide case. And a number of others, Wyndham, Nationwide, Yes, Target, and Home Depot. You're probably a class member, Professor Ford, and at the reception later you should have counsel for our. we have no
I'm conflicted out of this panel
Yeah,
now. is what
no,
you're
it's
saying?
okay. You just need to have counsel with you if we talk. So it's been a very exciting time. The thing about from my perspective about these cases, I'm an incident response guy. I can talk about compliance matters up front from my experience, but we're involved in the incident response part of it, and I think that people don't appreciate what really occurs when one of these cases breaks. You've got to get in there immediately. You have to find out what really happened. What did the hackers really do? What did they really access? No guessing. Get the forensic evidence, get it straight, get it in a privileged fashion. Make sure that you have Professor Smith with you to sort of tell you that, what it is that you're messed up about as you try to analyze the data. You've got to deal with law enforcement. And they're usually breathing down your back to get the bad guy, but they aren't really sensitive to the fact that you're also representing a client who's got its own issues. If it's a credit card breach, you're going to have Visa and MasterCard coming after you, insisting that you start an immediate forensic investigation using their investigator, bringing them into your shop, and you've got to give them free rein to look at what occurred, and you don't control them. You can't control them. That's part of the contractual relationship. The upshot there is tens of millions of dollars of fines and assessments that you're facing. So it's a big deal, and you have to decide whether you have to notify customers, whether you have to notify attorneys general. Do you have a duty? Figuring out the answer to that question is one of the most important things that you do in those first few very feverish days, because if you do have to disclose, the world's going to fall down around you like a ton of bricks. Within hours of disclosing, you're going to have class actions filed all around the country. In TJX, there were 32. In Sony, there were 65 class actions filed all around the country and in Canada. You will have the FTC and other regulators. In Heartland, they're in the financial services industry, so there were other regulators sending you questions, demanding answers, and giving you very little time to provide those answers. You'll have attorneys general from New Hampshire, Massachusetts, all across the country, individually sending you their questions and looking for immediate answers. Privacy commissioners from Canada and the UK, if it's a big retailer. You'll have class actions, not just by consumers, but incredibly, I don't know that any of the drafters of Rule 23 ever expected that this would occur, but the classes that you're facing include classes of banks coming after you for the losses that are associated with a credit card breach, which they signed up to bear when they went into the credit card business, but now that this has occurred, you're facing a class action from them. You've got securities and shareholder class actions, 10b-5 cases where plaintiffs will say you didn't adequately disclose the risk, or derivative cases where people will challenge the board of directors and say they weren't really paying attention to, or the executive officers, that they weren't paying enough attention to securities issues. And you've got consumer inquiries. There's a lot of press. Consumers have a lot of questions. Consumers many of them are inclined to sort of assume the worst. And if your client is trying to deal with their customers, their livelihood, they need those customers, and you have to work on all of that. And through all of that, even though you're the one who's been criminally attacked, a lot of what you spend time on is dealing with regulators and third parties who are requiring you to take time to sort of deal with them examining what your responsibility was. You're attacked, but everyone's looking at you as being somehow responsible for this. You know, in the 30s, when bank robbers with Tommy guns went and attacked the banks, J. Edgar Hoover went after the government went after the bank robbers. These days, it sometimes seems odd that you don't get the benefit of the recognition that you've been a victim as well, notwithstanding everything that you might have been doing to protect that customer information. So the things are aligned in a slightly different way. Those are all personal information breaches. More and more now, you're seeing press coverage being paid to hacks involving non-personal information, sovereign state espionage, the theft of IP and trade secrets, you know, the whole Homeland Security. I have a line. I used to say there's two types of companies: those that have been hacked and those that will be hacked. Then I changed it to say there are two types of companies: those that have been hacked and know it, and those that have been hacked and don't know it. Then I saw someone from Homeland Security. I don't know if he stole my line or I just somehow got it from him and didn't realize it. But his version was there are two types of companies: those that have been hacked by the Chinese and know it, and those that have been hacked by the Chinese and don't know it. And then you read about Adobe, people going into Adobe, taking a lot of personal information, but also just stealing the software that's on all of your computers. So they can now decode that software. The New York Times had an article just yesterday about how infrastructure networks, you know, utilities, are really being hacked at an alarming rate now. In August, the SEC went after a bunch of hackers and arrested the hackers themselves, which is great to see them get the bad guys, focus on the bad guys, and people who were using the information that the hackers had taken from newswire services. They grabbed the press releases submitted to newswire services and read them an hour or two or three before the press releases hit the press, and then insider trade on that information. No lawsuits that I know of yet against the newswire services. But think about that. What duties do they have? What about the company companies that gave their information to the newswire services? What obligations might they have here? Very interesting new alignments, and that's what's one of the great and very interesting things about this. And then you've got just plain old overreaching. I sort of think of them as overreaching cases, like the St. Louis Cardinals and the Houston Astros case. It's companies that either can do it, so they do it and don't think about it, or you've got rogue employees who can do it and do it and don't think about it. I was getting ready for this. I found a video online from a St. Louis TV station where some lawyer was trying to say, well, that St. Louis thing was just a rogue employee. You know, it's not like an organization like the Patriots. Which really got me upset.
Oh boy.
But the and it's not just that. You saw in the Wall Street Journal about a week ago. There's a lawsuit that is going on involving Uber and Lyft, where Uber is speculating that they had a hack a little while ago where 50,000 drivers, information for 50,000 drivers was taken. They got sued in a class action. Months go by, and now it turns out that they think that they have reason to believe, and they're, serving subpoenas that someone from Lyft actually is responsible for the hack. So that's fascinating. There are a lot of other cases. I know of a case involving employee recruiters where, up-and-coming startup doing really well, being very successful, happens to be upset that they lost a customer. So they go to their own files, they get a hashed password, they go to a rainbow for a customer who left them to go to a competitor, go to a rainbow table and decrypt that password, and then, just like in maybe this case, use the password to see if they can get into their competitor's database, and it works. That guy's now he's spending 2 months in jail, spending $250,000 on a fine, and $250,000 on restitution. So it just shows that the targeted, the type of data that is at issue here is very broad, a lot of types of data, not just personal information, but it underscores that every company is at risk, and every company is now going to have to start thinking about security, like the way that they think about making sure that their electricity outlets are safely installed. It's going to be a sea change going forward, and when incidents then do occur in this circumstance, everybody really needs to realize, not just companies that own personal information, but all companies need to realize that they have to have an incident response plan in place and ready to go. So that's mine.
Awesome. Actually, I'm very happy to go after Mark, because that just validates what I've been working on for the last 5 years and all of the time I've been putting in, the team of us have been putting in to protect the information of our customers and some of our probably not so much as until recently, our trade secrets. So I'm Mandy Petrillo. I work for the Red Sox, and I also work for Fenway Sports Management, which is the sister sports marketing arm of the Red Sox. We have one legal team that works for both companies. I'm in charge of legal operations, but I also do a lot of contract drafting, sponsorship agreements, event agreements. Keep it at that for now. So as far as it relates to this topic, about 5 years ago, actually after the TJX breach, the IT department and legal got together, and we created a team of people to come up with a policy to protect the personal information of our customers, which is basically our fans. We had to figure out a way to make sure that no one can access our fans' credit card numbers and social security numbers, which we really don't take socials for anything anymore, but we do deal with a pretty good amount of credit card information. So back in 2005, we created this policy. I'm sorry, back in 2010, we created this policy, and have been training on it since. And what we've been doing is learning from TJX and we're learning from the regulations that were put in place after the TJX breach, and coming up with safeguards. So we do it in 3 different ways. First is putting the proper IT systems in place. Our technology department is very savvy, and especially with the help of MLB, we have implemented some encryption devices, and I'm going to let Sean talk about the technology side, because I don't have the lingo. I feel like I learn a new acronym every time we have a meeting with the IT group. But so putting the systems in place to make sure that people can't get into our network and access our software, access our web-based systems that not only have customer information in it, but also any of our systems that actually have any player information in them. Medical records, there's a high sensitivity to any of that. Any scouting reports that we have, and most of you probably know that the Red Sox are very IT savvy in their baseball operations world, and we actually create our own system, our own in-house system for handling that data. So it's making sure that everything is locked down appropriately, and that is always ever changing. And with MLB's help, there are some larger initiatives that are being worked on now to make sure that, especially in the wake of the Cardinals-Astros situation, that each team is putting the appropriate safeguards in place to protect their information, whether it be from their own people or from outside hackers. The second piece is and the most important piece, in my opinion, is training. So, you can do as much as you can possibly do to lock down your systems, but there's always going to be someone who's smarter than you, right, that will come in and be able to get in. So what it is to teach the people who work for you, who work for the company and who handle this type of information, to change their passwords, to not keep these documents on their laptops at all. Make sure that if they have to keep any sort of credit card information or social security numbers, that they are, password protecting these documents. And it seems, it seems simple, but there are so many people, especially who work for the Red Sox, who have been there for a very long time. And some people who have had social security numbers written down on pieces of paper in their desk for a long time. So it's teaching people how to do things in a way that the credit card numbers and the social security numbers aren't even out there for anybody to grab. And that's what we've been working on for a very long time, or for 5 years, which feels like a long time. Training is, so the second piece was training. The third piece is handling the contractual arrangements with some of our vendors. We recently did a deal with or are working on a deal with a company who's going to be handling some of the medical information for the players. So making sure that those agreements are tightened up in a way that we know that any information that's being stored on there, that they're handling for us, that we're providing to them, are only being stored in our own environments, making sure nothing is on backup servers, making sure that in the event that the agreement is terminated, what happens to that data. And obviously everybody has to sign an NDA. There's tight confidentiality provisions. So, we have to make sure that anybody that we're contracting with understands the safeguards are in place for handling our information. So those are the big things from my perspective that we've been working on, and I think I'm happy to say that some of the employees are actually starting to get the hang of it. The baseball operations people have always been very savvy, like I said, so I'm not as worried about them as some of the people who handle some of our customer accounts. But they've come a long way, and I'm proud to say that I think I beat it down everybody's throat. So we did the trainings in person the first 2 years did it in person, so now we're web-based, so we're much more savvy now. But I think that's a good summary of what we've been doing to not have to call Mark.
Okay, so I guess I'm here to represent the entire computer industry and the U.S. government. Let's see. So I guess since the turn of the century, I've been at Dartmouth because, as I joke, working with students is possibly a more effective way of changing the world than doing things out in the real world. Although before that, I was at IBM, and then working for the U.S. government at the dawn of this thing called the web, when various citizen-facing agencies were saying, "Gee, can this help us? What are the issues?" And so it was very, very interesting, seeing all these dramatic changes in technology and how our ways are, as however you want to define that, as individuals at an enterprise, at end users, as people crafting law and regulation, as engineers, how we understand and think about the technology and what it can do keeps breaking, keeps changing. Very interesting times. So I guess one of the things I was Roger had asked me to discuss practices. So yes, there are what are now, I guess, good practices, best practices. Wait a few months and they'll be different. I remember when I saw the headline about the Astros, Cardinals, FBI investigating Cardinals hacking, and I'm thinking, what's the Vatican doing now? But it looked like it was just, okay, there was a list of passwords. First of all, he had a list of passwords. Why did he write passwords down? Why are you using password authentication? Why not two-factor? Why not a scheme where the password unlocks a private key living on your machine? You take your laptop with you. You can't get into that site anymore because you don't know the private key. There's ways to authenticate without giving away a secret. But anyway, that's it's okay. Practices. You see a rush to shoddy information engineering practices everywhere. As an exercise, find your favorite hacker friend and have them run Shodan, this search engine that looks for embedded systems, computers that don't look like computers, and see what they can find. I had some students do this as an exercise. It was terrifying. And things dealt with default passwords. You should know better than this. So let's see, that's one problem. Technology. We sort of know how to build bridges, and we know, okay, this is how long it's going to be before it gets rusty, and then we can maybe take care of this. We know how to build houses that don't burn down most of the time. We don't build the roofs out of cardboard and things, and we figured out, safety and insurance, and it sort of works. We're not there at all with IT. I mean, even if you deploy what you think this is the best of breed lockdown system, there are holes there, and you're going to have to worry about, running like through the looking glass, running and running and running like the Red Queen to stay in the same place. Oh, we have to keep patching. It wasn't patched. We believed it was secure, and 6 months later, now there are holes out there. Let's see. Something else I see that I'm worrying a lot about, and connects to this idea of how do we reason about things, is that infrastructure is both going through these transitions and connecting in ways that people don't expect. I mean, did Target think about HVAC? That was the avenue in. People say, why do I worry about computer security for my refrigerator? And some people at DEF CON looked at the refrigerator this summer, on one of the smart refrigerators. It knew your Google password for your Gmail and for your calendar and stuff. It was doing very bad, incorrect practices to authenticate who was talking to you. So your refrigerator could be giving away your password to, whoever happens to be listening to it. Refrigerators have been co-opted to send as bots to send spam and DDoS attacks. At a hospital, at Dartmouth, I've been spending about 10 years now looking at cybersecurity for the power grid as part of a consortium with the DOE and DHS, and looking at large hospitals and looking at the financial sector, all of which is very interesting. We saw a large hospital whose IT stuff was down for about a week because of a virus in a radiology machine. It was an old Windows machine, but who looks at, look at that, you don't think about, oh, that's a Windows machine, let's patch the computers. Are you patching the radiology machines? We had a problem at Dartmouth where we discovered that the set-top boxes, so students could watch cable TV in their rooms, were very shoddily secured Linux boxes, very easy to break into, put malware on, and they would still work well as set-top boxes as well. The vendor decided they weren't going to do anything, so we stopped using them. But there are millions of those out there. You're worrying about securing your infrastructure. You're looking at the set-top boxes. Even with Dartmouth, when we changed from a tethered Ethernet to wireless, it was amazing what you could do and all the clever ways we could steal passwords from people and watch their email, because you just don't think of, it's okay over a wire, but now I'm just broadcasting it. So the infrastructure keeps changing. I remember even in ancient times, a bank used redundant networks from two different suppliers because they wanted to have high rate availability, but they both subcontracted to the same place, and one backhoe took out the redundant networks. Everyone's criticizing Daimler Chrysler for having this flawed equipment in their cars. This radio, the way it was handling cell phone stuff had some interface vulnerabilities that led to the car being taken over. Well, first, they didn't build that. They got it from a third-party vendor. What other companies bought their radio equipment from that vendor? What else is vulnerable? Secondly, these hackers, they got good press coverage. All of this was published in the open world 4 or 5 years ago. Who paid attention? Volkswagen now is in the news for, we have evil software in our cars. First, Volkswagen spent 2 years trying to stop some people who found holes in their wireless keying system. Second, it's gratifying to hear things like NPR talk about this little-known law called the DMCA, which wasn't little known in my world 15 years ago, where, hey, guess what? It's illegal to look at the flawed software and to point out a hole. So okay, that's part of it. I guess the last thing I would say is, Parkgate. I want to make the world a better place. What levers do we have to make things better? One of the problems why we've had bad credit card security for a long time is the people who can make it better aren't the ones who are losing the money. So there's no motivation. I saw things work well in Wall Street before the downturn because the traders got convinced that, oh, this security stuff helps us make money. We like money. I've had a major person at a large hospital tell me, are you here to build a better policeman, or do you want to help patients? It's not the same thing. So they have, that users have to be motivated. Law, what do you go for? NIST sort of goes well with some of their security standards, although when I was at IBM trying to build stuff to get it validated, it's a mess. Then you have things like the DEA's electronic prescription for controlled substance stuff, which was written by someone who had never really smelled a computer, I don't think. Cryptography, I remember the crypto export wars back in the 90s and 80s, and maybe we're getting back there again. On all kinds of levels of law, of public policy, of what you're going to use on both ends to defend or to make things better, it's way up in the air. I guess two final comments. Think about the adversaries. I would think not just the Cardinals hacking the Astros, but who else could benefit from knowing inside information about a sports team? Organized crime with gambling. There's New York Times this morning had stuff on gambling issues with fantasy sports, maybe the real sports too. And adversaries going after machines just because they're interesting and can be resold in the market. And the last thing, I guess no one in my world really thought that, really surprised that North Korea was blamed for Sony. Most of the hackers I know are still very bitter about Sony shipping essentially rootkit malware on their CDs for music protection way back, to the point where people were using a Sony as a measure of bad behavior of a company. Oh, that was about 5 millisonies. So serves them right. Anyway, I guess so. Things to keep in mind: law is messy, practical technology is going to be changing every few years, paradigms shift, and watch out about blaming the hackers and blaming. If we had a DMCA for the car industry, Ralph Nader would be in prison and we'd all be dying in Corvairs. And if back Bob Morris Jr. when he got arrested for and prosecuted back at the Morris Forum of '88, the big one of the big breakthrough things in the public world. He accessed computers without authorization. Well, guess what? The computer systems he accessed didn't require authorization, or they had holes that everybody knew about, but nobody bothered patching. So whose fault is that? Yes, you shouldn't light fires, but you also shouldn't claim to have those bad arsonists. If and I should get a big insurance payment because I built my house out of cardboard. It's okay. There's a bit of wake up some controversy. Hackers are good.
Oh boy. As I suspected, I don't know why I'm here other than I'm the father of a BC Law School grad. I've been to Fenway Park and I own a computer. Now, I guess the hook here is the Cardinals-Astros thing and espionage and how it plays out in professional sports, I'm guessing. Espionage in baseball is an honored tradition, but there's legitimate espionage and there's illegitimate espionage, there's espionage and there's cheating. There's a difference. Espionage is really, for 130 years or so, from the beginning of organized baseball in the 1840s through the 70s, basically consisted of stealing signs, which was all on the up and up. You watched the third base coach or the manager looked at the other third base coach and tried to figure out what the signs were for the steal and the bunt and the hit and run and so forth. And there were people who were very acclaimed for their ability to do this. And I remember growing up reading about all this stuff. And it was, but that was okay. Everybody did it. And some guys are better than others. There's nothing illegal about it. But there's other aspects of baseball that but one of the no-nos, one of the absolute positive no-nos is a batter is not allowed to sneak a peek peeking back at the catcher to either see the sign, which is probably impossible, or to see his movement, which is not impossible, to see whether he's setting up inside or outside. This is a no-no. You do that, and you can expect a 90-mile-an-hour fastball heading for the coconut on that one. So you can't do that. But what but baseball is always, to me, in my mind, it's interesting because I never thought about it until tonight in connection with this whole idea of the hacking of this potentially very pertinent and important information. Is that it seems to me that baseball's had a contradiction in this regard because though each team has its own scouts, and these scouts are out there for scouting amateur players for the purposes of the draft, and B, Major League Scouts scouting other teams for the purposes of trades or upcoming series or preparation for postseason. At one point in the 60s, they suddenly developed, after they decided to have a draft, remember the baseball draft was instituted in 1965. And up to that point, every team went out and signed all its own players. Anyone could, any way you want it, no problem. There are no restrictions and you open up a checkbook and you got your persuasive scout out there and you sign the players. And then since 65, we've had a draft, a la the NFL, whose draft was instituted in 1936. And then they came up with the Major League Scouting Bureau, a consolidation of a consortium of scouts, and various teams signed up so that they were pooling information. Then and now wondered, why it was economics, I guess, for some teams. But and then there were a couple of major scouting combines that came up. One was Blesto 5, I remember, and But the point being that it was okay to share that information. So I'm a little confused about all the furor about sharing information. But what we're talking about here, and let's talk about football for a second, the paranoid sport, the complete paranoid sport is football. And the Belichicks of the world, and he's just the latest in a long line. He didn't invent paranoia in football at all. But what he did, of course, is adopt a brazenness to his approach that landed him, the great sanction of Spygate. And that's a whole other topic, Belichick and his foibles and his genius and his inability to draw a line and all that. We can have that discussion some other day. But football is a sport where people, oh my God, practice information is sacrosanct. That's what Spygate was all about, taping of practices, walkthroughs, and trying to get down defensive signals, so on and so forth, and anything else they could find out. This is obviously a no-no, but you always hear these stories. I remember the Giants, when they were at one point in the Meadowlands, were accusing somebody of any of you familiar with the setup at the Meadowlands, but that hotel, the Hilton, is not, people were supposedly, they were afraid that people were getting rooms in the hotel and then getting high-powered binoculars and spying down on their practice field. Oh, yes. Well, football, that's football. And basketball has adopted that more or less. When I started covering in 1969, every practice was open, but now no practices are open. And one of the reasons, there's a variety of reasons, but one of them is the fear that some writer would write something that would reveal a tactic or not just an injury, but perhaps even a tactic. And they didn't. Nobody wants that, so no practices on any team are open. But we get back to the whole thing here and what are we talking about here? We're talking about this. There's always been a desire to gain an edge in a variety of ways in all sports, gaining an edge. I don't care what sport you're talking about, trying to gain an edge in different ways. But now we have entered into the world of technology. And technology has been wonderful for, well, I mean, I don't want to tell everybody knows we all benefit from technology, but there are potential downsides. We're discussing these downsides here, and sports are not immune to it. So now baseball and all sports have to recognize that, okay, they have the technology, but they have to protect themselves. And there's something that I was wondering when the whole Cardinals-Astros thing was brought to light. I'm sure the reaction was one of two ways throughout baseball. There were the people who went, it's an idea, its time has come, I knew it was going to happen, or B, what? What? I mean, what? So, and now everybody's aware that, they have to adapt and have to protect themselves. But in sports, obviously it all comes down to the idea of gaining an edge, and And that has always been part of the deal ever since we've had organized sport.
All right. Well, thank you, everyone, for your thoughts. So I thought I would start with a question about the scope of the problem. So in my IP survey class, for instance, we talk about in trade secrecy how there are a couple of classic threat models that have come up over and over the decades in trade secrecy. So one is a competitor trying to steal a competitive advantage from another company. Another is a rogue employee or a former employee who either is trying to take information to a new company or is just disgruntled and wants to hurt their former employer. But now we're really seeing these new models. So one is, the nation state, something like North Korea and the Sony hack, and another is random person on the internet who might steal information for entertainment value, maybe because they're gambling based on it, maybe for no real reason at all. And so Sony obviously is the nation state model. The Astros may be the competitor model, which may seem like the sort of classic model, but it's not the thing we're seeing over and over with credit cards and things like that. So do we know how, so for instance, Mark, you talked about how in those first couple of days, the question is, do we have a duty to report this? And how there are companies that have been hacked and there are companies that don't know yet that they've been hacked. So do we know how often these things are happening and not becoming public? Do we know if North Korea has information about all of the other movie studios, or if other teams have hacked their competitors? How do we know this kind of thing?
The sort of accepted knowledge is that most hacks are not disclosed. I mean, there are a lot of hacks. First of all, there are a lot of attempted hacks. You talk to any retail company, they'll say that their website gets pinged in a way that isn't just a customer using the website up to 10,000 times a day. Very hard for them to track. Very easy, and very easy to see what's happening, but very hard to sort of test and make sure that something doesn't get through. And what a lot of hackers will do is they'll try to come in looking as if they were consumers. And anyway, so there are a lot of hacking attempts. And if your question is really with respect to those that actually succeed and get in, how many of those are ultimately disclosed? And
or even discovered, for that matter.
Well, there are a lot of. There's Ponemon Institute has a lot of statistics about this. The average number of months that it takes companies to sort of first find out that they've been hacked is it's something like 8 to 12 months. The most hacking comes to your attention not because you found it, but because other people bring it to your attention. That's how most credit card breaches occur. Or you'll get a phone call one day saying, hey, there are credit cards on the web that look like they're attributable to you. Or people will actually call and say, somebody's used my password and I only use it with this company, something's gone wrong. So it's rare that you find it yourself. I'm in situations with attorneys general all the time where I say, look, I've got a client who found this incident itself within an hour of it having occurred. That sets my client apart from most other companies that you go after. But the short answer is that most people assume that most breaches are not disclosed. Because if you don't have an obligation to disclose it, by keeping it internal, you avoid the bad publicity, you avoid losing trust with your customers, and you avoid the inquiry that you're always going to get once you become public, where people start to start to challenge your own bona fides, your own good faith effort to try to protect the data. Just today, an hour before I got on the car to come up here, someone sent me a link to a New York Stock Exchange 350-page report for directors of public companies on how to handle data breaches and how to deal with the data security issue. Boards of directors are much more sensitive to this issue, we've noticed, since the beginning of 2014 because of what happened at Target, where the chief information officer left shortly thereafter, and then the CEO later left, and there's a debate over whether it was attributable to the incident or not. But this I have it here somewhere. It's a flow chart. It says, okay, was information taken? You have to make that determination. If it was taken, was it material? If it's material, then you lean in favor of disclosing. If it's not material, then the question then is, well, is it going to get disclosed anyway, even though you don't have to disclose it because it's not material and you may not have a duty to disclose it? Or do you want to get ahead of the curve and disclose it anyway because you'll look bad if you didn't? Or if you're not sure whether it's material, then you sit there and say, well, okay, we don't think it's material, but might there be somebody else out there who thinks it's material and they're trading on it? This is a very complicated flow chart. I'll find it in some while someone else is speaking, but the analysis is important because if you don't have to disclose, it's a reasonable thing not to do it in many circumstances. It's always going to be fact specific, but the downsides of disclosing are usually pretty substantial, so it's got to be worth it.
Any thoughts from anyone else?
Well, I think that you also have to factor in the PR implications, right?
Yeah.
Because when, obviously if it's an actual breach and someone used that data for their own advantage, you have to report it. But if you're analyzing whether or not to put it out there, as soon as it gets out there, it's in the news. And when you're a company like the Red Sox or Home Depot and TJ Maxx, everyone's going to pay attention to it.
So here's a great example of how these things can be really, really critical. PR guys, we fight with the PR guys in every case, every single case. There's been a hack. PR guys are going to come in and say, oh, you got to get ahead of it. You got to disclose. You'll be much better off. And they say, so what happened here? So the hackers were in there in February, and you're still not sure whether they, when. Why don't you come out and say, okay, could have started in January, but it definitely ended in March. Then you're ahead of it. You're not going to come out, not going to get worse. You've covered yourself. And we sit there and say, don't rush to say anything. Professor Smith is still looking at the data. Let's really make sure what happens, because if in fact they were only there in February, which is what we currently think, by trying to sort of get ahead of the curve PR-wise and saying, well, it could have been from January to March, you've tripled the size of the class period for the class actions that are going to be coming after you later on.
In minutes, probably, right?
And you've invited all of a sudden AGs to sort of say, well, okay, so now I thought I had only 10,000 customers in my state, but maybe it was 30 because it was a 3-month time frame. And and you can't walk that back. You can't later on, 2 months later, say, we've determined it was only February. It doesn't matter. The class actions have started. The AGs are after you. And nobody's going to believe you when you say, oh, it was really only a shorter period of time. So that's the disclosure. Even if you decide to make a disclosure, how to make it and what to say these are very tough decisions.
Well, and I saw a story a few days ago that said that looked at maybe a dozen recent data breaches and said that the number of people that was affected by the breach, according to the first announcement, was typically about half of what it ended up really being. And there were always later announcements expanding that.
Well, those weren't our cases.
Of course not. Those were the terrible companies and the federal government and things like that.
A couple quick reactions. First, you're discussing potential adversaries. You also have these sort of quasi-criminal organizations that do ransomware and things like that.
Yeah.
That's something you do in the news for end users and small businesses. Hey, everything is encrypted unless you pay me $500 in Bitcoin. You don't get your data back. But there's, rumors that that sort of thing may happen on a larger scale. You pay us this money or we're going to shut the rest of your factory down. It's hard to know if this is all rumors, by definition not public. It's hard to know the extent of that. At least in some of this, probably not relevant for sports as much, but I don't know. I could see terrorism is a big concern, at least from some of the power people I've been working with.
And that's something the
and
NFL has been very concerned
Yes,
about.
well, that's a sort of, so you have a high-profile event, you could do something. For information sharing and disclosure, kind of in between there, one of the things, well, we were surprised, we found when we were, some students and a colleague and I were looking at some Wall Street stuff, that, the one bank said, oh, the security people at that other bank, can you introduce us? And that there's a lot of, sometimes formal, sometimes informal advantage, or things in place to share information that way, and that can be helpful. Oh, my competitor was getting this attack. Hey, look, we're seeing it too. And that can sometimes, and that there's a tension because you're talking to your competitors. But there's also, by pooling information, maybe you can all see the attack coming before it gets too wide. Another kind of disclosure I see a lot in my field is when people go to a website or go to a vendor of equipment, go to Chrysler and say, hey, you've got this big hole in your stuff. Well, what is the reaction? Often the reaction is, we're not going to do anything about it. And then a year later, if there's a problem, it's sort of, there's a tension there. How do you react if someone comes to your firm that you represent, to your lawyers, or soon-to-be lawyers, and says, we found this hole, you're negligent. What do you do? What's the responsible thing to do?
Depends.
Yes.
But so I guess
Answer to all
I'm
questions.
I guess I'm wondering if the Astros hack hadn't been leaked, if it hadn't become public, is there any way we would know it had happened? Do we know if other teams might be doing this thing? I mean, Bob, you mentioned the sort of unwritten rule in baseball that you don't look at where the catcher is
Right.
setting up. But, there have been reports that, like, Alex Rodriguez does that. He's been caught on video.
Oh, of course he would.
So, yeah. So, there are unwritten rules, and then there are unwritten rules that are broken. And do we know where this falls in that spectrum? I mean, is this something teams might really be doing?
I would think that no one else would be willing to admit it if, right now, we're talking about disclosure. And, I mean, who'd want that for all the obvious reasons? The answer to your question is, I don't know. It's certainly conceivable. I mean, that the ingenuity did not just reside in these allegedly rogue employees of the St. Louis Cardinals, that there may be other young whippersnappers of...
all the teams except the Red Sox.
Right, with a wherewithal and the inclination to get something done. Because now we're moving more and more into technologically based, analytically based operation of ball clubs, and it's almost universal now. I mean, I don't know if there's any team that's actually any longer an official holdout in this regard. So, the mentality that goes along with it in terms of this is just new and different. I don't know. This is and baseball of all places. This has been such a conservative institution for so long, and it's change in baseball is very hard to undertake. And now we still have this great dispute about the analytics people versus the eye test. Which is, I think, a healthy debate, frankly, and the truth is probably somewhere in the middle, naturally. But analytics are ruling the day.
I think that the trade secret thing, the analogy here is that you can't bring a misappropriation of trade secrets claim if you don't have a trade secret. And if you don't keep the know-how that's your trade secret, the proprietary approach that's your trade secret, if you don't keep it secret, courts are not going to give you any relief. So, when I'm in a deposition in a trade secret case and I'm deposing the inventor, I ask the inventor whether the inventor talks to his family about the trade secrets, because that's a factor. It may not be dispositive, but it shows whether the owner, the alleged owner of the trade secret, is really keeping their information confidential. If you lose it on a bus, it may be gone. Even if you were trying your best, if you have just an accident and it gets disclosed, you can't unring that bell, and there goes your trade secret. So when I was thinking, if you watch baseball games or football games is a better example. You see coaches on the side and they're talking on a microphone, but they're holding their piece of paper up like this, and no one can read their lips.
You know who started that in sports, in my opinion? Roger Clemens. Roger Clemens was talk about idiot savant. Believe me, Roger Clemens was the first person I recall who realized that the television cameras were capturing what you were saying, and now it's universal. Everybody does it. Football, everybody in baseball goes out and puts the glove over their mouth. And in football, they put but everything has a beginning. And I mean, these things. And I'm telling you, it was Roger Clemens that started this entire thing.
Yeah, and I just think, the notion that you shouldn't, if you've got a hotel that's next to the stadium, of course they're going to look. I mean, it reminds me when I was a kid, I remember getting Mad Magazine, and there was the golden rule, do unto others as you would have them do unto you. But in Mad Magazine, they had the Spy versus Spy had a version that said, do unto others as they would do unto you, but do it to them first. Because, of course, if you don't take steps to protect your information, people are gonna get it. And what court is gonna come help you about that? One of the first great project I had when I was a young associate is someone asked me to do some research on garbage law. There is law of garbage. It had to do with whether a private investigator could take stuff from somebody's trash can, and it all turns on the curtilage. Where does the boundary of the curtilage stop? If you put your trash on the street versus whether you put it on your lawn versus that strip of grass. And a lot of it is Fourth Amendment type stuff. These days, apparently, over time, the driveway is now losing its curtilage status. But it's the same idea. It's all a slippery slope.
If you put it out there, you've lost your right.
Have you abandoned it? Yeah. And you can do it deliberately or accidentally. But if you let it go, it's gone. And that's my approach about this. Some of these rules are kind of too precious to me. Of course, if you can see something, and you didn't, then you got to expect that other people are going to do whatever they can do with it.
What about restaurants? There's a case this week I read in one of the New York Tabs about a former employee opening a restaurant, and the owner of the original restaurant is suing on recipe theft. No, I'm not. But think about that. I'm surprised that doesn't happen all the time.
Yeah.
Well, and so I wonder how this plays out when we're in an era where teams and public figures are becoming more and more transparent about this, as social media becomes a thing, as Hard Knocks is on HBO, and we see a lot of these preseason practices and meetings where they're talking about their strategy. I mean, I have a former client who was an actor whose contract said you have to maintain a Twitter account and you have to tweet a certain number of times a week and from set and things like that. And we've seen, teams doing the same thing in sports. Is that going to make it harder for these things to stay secret? I don't understand why any team would ever go on Hard Knocks, for instance.
Well, the Patriots don't. And no, seriously, and you're right. I don't understand that either. I mean, but some of them. Well, Rex Ryan was a attention seeker. He craved it. He loved it. That there's always outlying circumstances of individual personalities, I'm sure, that would explain it. But most teams
Marlins just needed some sort of publicity.
Yeah. No, but it's an interesting point. Yeah.
Plus, I can't pronounce the guy's name. I should be able to pronounce other people's names. If anybody should. But the guy that moved from St. Louis to the Astros.
The general manager.
Jeff Luhnow.
Yeah. He said. I mean, his reaction was the data had no value anyway, because it's that data, that trading data, has a very, very, very short shelf life. Within a short period of time, it's useless, and so they got big deal. So he posted this data, big deal, and then lawyers were posting notes saying, well, there goes your economic espionage claim, because if it had no value, then you can't bring a claim.
Well, but the value it might have, though, is it's a signal to, say, for instance, a professional gambler that this is the kind of information that if I find a server I can get a hold of and, trade on. I don't know if that's realistic or not. You seem to look skeptical.
If you have the
No, I'm not,
passwords,
I'm
right?
not, no, I guess I'm thinking more, we're discussing what are the rules of fair play in baseball? What are the rules of fair play? Do you cross those rules? And I guess with sort of the rapid changing in technology and the way it's kind of permeating in places it didn't permeate before, and the connectivity that's possible, there's just there's a whole lot of gray areas in terms of, I mean, people my generation who freely traded cassette copies of albums when we were kids were condemning those bad people who are doing music downloading. Now it's just sort of the scale changed, the quality changed, and economic impact changed, but they talk to a young college student and they think, oh, this is perfectly fine, isn't it? It's sort of Apply Yourself is a third party. Maybe you used it when you applied to grad school, law school. It was a case about 10 years ago where some students figured out that they could log in as themselves and then edit the URL and discover whether or not they'd been admitted, because the information was there, it just was a little hard to get to. Oh, hackers. Well, anyone who's done a literature search in the postcard catalog world, you edit URLs all the time. Oh, gee, I found this paper. Can I find the table of contents? What's acceptable behavior? What's not?
And then the government takes the position in the AT&T case that that's a felony.
Well, and so that's something that yes, this is, it's an interesting
Yeah.
times.
It depends on your context too. The Uber Lyft case is an example of this, and it sort of fits with the Alex Rodriguez story. That case came up. What came out over time was that there was an Uber programmer who was trading code on GitHub and put some Uber code up on GitHub, and apparently didn't realize that it included the key that allowed you to get in to the network. Didn't realize it. It had been up there for months and months and months. And if you're a lot of other people knew about it. So it's out there. The secret's gone. And now you know it. What do you do? The debate in the blogs is some people saying, well, once the Lyft CEO knew that the Uber key was out there and code was out there, of course you'd go take it. You would be foolish not to. And other people said, no. Even though it's there, even though it's available, you have a responsibility to your company to avoid the other ramifications of it, and you shouldn't go do it. I'll tell you this: if you're the AGs, will if you're talking with attorneys general, they're going to say, I would imagine, it's not in that case, but I'm speculating that an AG would, because their focus is always, this is your fault. You were hacked because you didn't have good enough security. You didn't have good enough procedures. And it's always a sort of after-the-fact, 20/20 hindsight analysis. But they're saying you shouldn't have put anybody in a position where they could have had the data to hack in, and you should have had two-factor authentication anyway, even if they got the key. So that's not, this day and age, you should have more than that. But on a trade secret case, I could easily say that I could easily see Uber saying, all right, fine, my key was out there, kill me. But that doesn't mean that somebody can actually take it and use it to get into my network. That act but you can't do anything with a key unless you use it. And if you have a key, in circumstances where you know it's inadvertent, which they would say is obvious, then you can't say we can't assert a claim against somebody who took advantage of that situation.
Or even when it's not put on GitHub, but like in the Ashley Madison hack, it turns out some of their passwords were hard-coded in the source code for the site, and that's one of the things that was stolen. And so it wasn't made public, but then it became public when it was accessed. Are courts are courts willing to look into that level of specificity on this kind of thing? Like, will the court say just using a password is a sign that it's not protected as a trade secret?
It depends on what the case is. If it's a trade secret case, I think then the secret's out. But if it's a claim, it's a class action where consumers are saying my personal information was disclosed because your security wasn't good, it'll be different.
So Mandy, you mentioned something I thought was really interesting, which was that the baseball operations people seemed more savvy about this stuff from the get-go. Do you think that stems from this culture in baseball of, you know, competitiveness with other teams? I won't say espionage, but, you know, where you have to maintain these kinds of secrets to begin with, or do you think it's just a function of who was there? I mean, how is this playing out in the culture of the league?
Well, I can only obviously speak for the Red Sox, and I can't speak that, Bob probably knows more than I do about the inner workings of the baseball operations department. They're a very tight-lipped group over there. But I think for a very long time, it's no secret that are in the sabermetrics model. So I think the same, I think that we've been following that system for so long that I feel like the people who are employed in that group, most of them have to have some sort of technological savvy about them in order to even understand how things are working.
So so it comes more from their technical backgrounds than from
right. And I don't think they necessarily have. I think a lot of the, I say guys, but there are a couple females down there that grew up in the system, so they've learned the Red Sox system. And like I said, it's proprietary software that one of our employees actually built. So they've grown up in their careers using the system. And I think that's where, I'd be shocked to think that any of them actually had a technology background outside of the Red Sox, if not from another organization.
Does that make it harder for people to move from team to team? The fact that we're now seeing teams build up these very, very detailed internal.
I think it makes the Red Sox employees very desirable to other teams. I mean, like Bob said, most of the teams aren't so much of the look and see approach. They're using the models that the Red Sox have been using for a long time. So I think that at least from what I've seen, the Theos are very, very desirable candidates because they have that perspective. And then they work well with someone like a Dombrowski who isn't the sabermetrics guy. So they have both now with Mike Hazen and Dave. They have the kind of the both ends of the spectrum, which
they can bring the statistics and the eye test together.
That's I think the idea, right?
That's their new model. I mean, that's their new circumstance. Yes,
Yeah.
absolutely. And the Dombrowski still is more of an so-called
old school.
But don't frame them. And this isn't John McGraw. We're still talking about the 21st century. He's just not. He's just more willing to give the benefit of the doubt to the so-called eye test than a lot of younger, analytically oriented GMs are.
Is this something that leagues are also looking at? Do you know if Major League Baseball is thinking about punishing the Cardinals for this, or if leagues are putting in place rules that would prohibit this?
Well, I don't think just from a PR standpoint, the idea of that kind of behavior is unseemly and uncomfortable, and that's not the way we want people to think that we do our business. We don't want to sanction anybody to think that we sanction that kind of approach to business. So from that standpoint, I'm sure they are very. I would think there were well-worded memorandum, I guess, sent out there to people. Take note of this thing. We don't want to be hearing about any of this from any of you other people.
Although, I mean, the NFL sent a memorandum about don't videotape other teams' signals, and we know how that turned out.
And it was duly ignored by a very headstrong and powerful individual, yes. Yes, and at the time. So.
I do know that the league is implementing a league-wide or team-wide, club-wide cybersecurity measures, or they're working on implementing league-wide measures that each team can then implement. And we're working, the same group of people that I've been working with since the beginning of all of this, working together to kind of come up with safeguards, find out where our information is, because a lot of times you go out, you have to fact find, you have to figure out, okay, not only where are our credit cards and social security numbers stored, which is what we did 5 years ago, but also who has access to these systems, where exactly is everything stored, what types of measures are being are put in place to change password. It's funny, the Cardinals Astros thing is a simple one person writing down their passwords in a place that everyone knew his password, and that seems like and I keep going back to this, but training people to understand that that's not ever going to be okay ever again.
Is it so far-fetched to think that they would be worried about incursion from other leagues? In other words, league versus league, for business purposes, not player personnel evaluation purposes, naturally. But I'm just throwing this out there. I mean, is that ever? I don't know. I can't ask you if you've ever heard it been discussed, but isn't it conceivable?
And it's interesting that I mean, even in this modern age where you really have people coming into sports who have non-sports backgrounds, who are just bringing in technical savvy and economics training or computer science training, we don't see a lot of movement from one league to another. You don't see analysts from baseball moving to basketball, which has surprised me. Because if they're just bringing that sort of general mindset, then maybe.
Well, there's a turf thing there. I mean, and I don't know that there are that many people who would be truly qualified to operate at the highest level of analysis or not. There'll be some. I mean, after all, there's countless talk show people athletes who are asked to comment on sports that were outside their original sport. And I know that, but that's a little different. But anyway, it's good.
I guess one last thing I wanted to bring up is the role of the media in all of this. So we see when classic sort of credit card style data breaches or the Anthem breach becomes public, there tends to be a lot of reporting that tends to lead to class actions. And then we see something like the Astros leak where it's really the information is going through the media and that's how it becomes a story. So how does the media get hold of this? What's their role in this? What's their responsibility? Should they be as loud about these things, or does that exacerbate the problem? I don't know what their.
Why is it the media role and concept of what the journalism and investigative reporting is all about any different now? It's just a specific circumstance. It's just a new specific. So I don't see how it's. I mean, the obligation, if you feel there is an obligation, to do that job, yes, it should be pursued. That's all. It's just a new topic as opposed to a topic that would have been relevant 10, 15, or 50 years ago. And it's the same. I mean, I'm not. Now we can say how important. What's important in society? Yeah, okay. We're not talking about Upton Sinclair. Going after the meatpacking industry here. We're talking about two teams in the National League. Two baseball teams. Okay, and so yeah, that's always a distinction, and to be made. But in general terms, in terms of this, the whole topic we're talking about here, and far more important matters than the little data from the Cardinals and the Astros. Sure, the media should be vigilant and determined and aggressive, I think.
But when do they cross over into being a conduit of the information? So like Deadspin itself didn't publish a story about the Houston Astros got hacked by the St. Louis Cardinals. They published a story. Here's some interesting stuff we got from the Astros database.
Oh well, yeah, you're right. Now, what Deadspin would have done with the information is opposed to what the Associated Press would have done with the information, or the Boston Globe, or the Houston Chronicle. Yeah, that's interesting. Well, they are a constant concern, to the people that they harass, and which are sports and entertainment people for the most part, and politicians, I guess, right? Oh yeah, they don't play by any known rules. TMZ does not play by the old rules. So that's an interesting aspect.
That was the Sony case. the Sony Pictures case, where the same thing happened. They got all these emails.
With Gawker, which is
And they posted
the same
them.
people, yeah.
So we worked on the Sony PlayStation case. There was a Sony Pictures part of it. We didn't work on the Sony Pictures North Korean hack. But the lawyers in that case sent cease and desist letters to companies. I mean, a lot of, and said, this is causing us economic harm, this is damage. You know, and Michael Linton, the president of Sony Pictures, has been out there sort of saying, look, we asked people not to do it as good citizens, corporate citizens. They knew it would cause us a lot of embarrassment. They just didn't care. A lot of them went ahead and did it anyway, and then they had lawyers get involved sending cease and desist letters, bringing claims like, you know, false light claims, the variety of different kinds of interference, and whatever you can come up with, to sort of show that if you're going to really do that, knowing that it's going to cause us harm, you can expect us that we're going to press our rights as fully as we can. But, you know, it's now the media itself, though, they've like, the fascinating thing is how well the media covered the UK cell phone hacking by the media itself.
Yeah.
That was a very, very interesting thing. They didn't show any mercy on themselves. They went completely after themselves there. So, and I think it's all legitimate subject matter. And we're learning a lot from we're just talking about it here. We're learning about how companies. I don't mind the reporting. What I mind about the facts. What I mind is that it's good if the facts are right. You see a lot of the facts not getting accurately portrayed. And I also think that there needs to be better reporting, at least in the personal information area, about the hyperbole. We should avoid the hyperbole. What people don't understand, the credit card, I know you're a class member, but the credit card breaches really don't have much of, they have kind of an impact on consumers, because you have to go to the inconvenience of calling all of your auto pay vendors and telling them I've got a new credit card. But I had in the TJX case, I remember there was someone in New Hampshire who brought a small claim. A small claims action in New Hampshire, had to go to someplace like Milford to defend this claim, where he said, I'm an engineer, I work at home, I charge $250 an hour, I have to spend 3 hours on the phone to get my credit card replaced, I want $750. And the judge says, are you serious? And he explained, he says, yes, this is what I do, I charge, I keep track of my time, here's my timesheet, this is what I actually did, here's my phone records, this is what I called. And the judge says, but you're using credit cards, it's just a feature of life. That's the cost, that's exactly, and we're arguing. Luckily, the consumer class action had already been filed with the court, and there was a provision in the settlement papers that I put together that said nobody can bring any claims while this consumer settlement is pending, and he'd already missed his opt-out period, so we got it dismissed on that basis.
Have I missed my opt-out period?
Let me see. Let me look it up. There is a settlement in the Target case, but I am not on the class action.
Do I get
part
anything out of it? Is this a coupon?
Target
or-
case,
7
no, the
cents.
Target case has terms that are different than you could argue. Well, I don't know. You just can't apples to apples, but they're different. You can actually get something there.
We've been discussing a bit the role of the media in publishing the data that's discovered in these kinds of things. As a technologist, an issue I see a lot and we discuss a lot, my colleagues and students, are disclosing the mechanism by which the breach happened.
And you mentioned the Target breach through the HVAC system. I think that might be worth explaining how that worked, because that wouldn't.
Well, I'll have to get back to you on that. I don't have those facts easily at my disposal right now. But it was through a contractor. It was not through the main computer system itself. It was
No,
something
but
with HVAC stuff.
it was like all the air conditioning systems ran on a central server, so Target in Minnesota could control all of them, and
But more, I mean, if you find here's this standard OS that everyone uses, or all the servers run on, or a standard web front end that people use, oh, gee, here's this huge hole. Well, what do?
if you don't publish it, the hole persists and everybody's worse off. If you do publish it, you're enabling the bad guys. If you tell the company and they give you a cease, then they hit you with an injunction. What do you do? It's an interesting, and I guess I can say in academia, I don't know. I don't actually have to make the end call, the end judgment there most of the time.
So I have a question though for you, because we hire experts all the time to help us with this issue. You try to sort of explain, advise your client in advance of an incident that what they need to do for their security to be reasonable. Or after the fact, explain to regulators why it was reasonable. You say, there's no such thing as perfect security. All we can shoot for is reasonable. That's all you expect is reasonable. We now know how it occurred, but just because you know how it occurred, it didn't mean that my security was unreasonable. But how do you show that? What are the standards that we can point to that are really, how does that, I've tried a number of different ways. You bring experts in, but I'm always interested in hearing people who are in the field talk about how best to articulate what the standards are.
Well, there are.
This week.
Well, no,
that itself is a good answer.
there are some. You can point to some NIST guidelines or ANSI guidelines or things, or different banking things. There's some general government. There's some industry-specific things. Here are the rules. This is considered best practice now. You can point to that. You can go to a real high-end, an EMC or a diner or somebody who's not a little more broadly respected and say, okay, what are the standards? What are good practices? But it's a hard.
It is hard. I like I would imagine if we could move to a safe harbor kind of an approach. It comes up in the payment card area a lot, and I could see this expanding in other areas as well, where you go to someone who comes in and audits your security and gives you a certificate, and that gives you a safe harbor until your next certification. And now that isn't foolproof, because then if something happens, everybody's going to come in and second guess whether your certificate was properly issued, and then maybe you sue your auditor if it wasn't, or maybe people, there are a lot of ways to maybe try to, litigation is litigation, and people will try to challenge the certificate. But coming in and getting a kind of safe harbor certificate at least gives everybody the same chance. If you're talking about you're in a competitive field where all of the other companies are in the same area, if baseball is going to impose a set of standards on all of the clubs in the league, how do you make sure that all of the clubs are really putting the resources in that are required and have done the job in a way that gives the clubs at the same time some comfort that it's being done in a way that you can sort of demonstrate and is going to be demonstrated in an even-handed way?
Yes, yes. That could be effective. I've seen things work both ways. Just like we look with, are you teaching to the test, or are you actually trying to teach to the students? I've seen organizations that say, well, we just want to follow these rules, or get the auditor to bless them. We don't care what the security really is. And if you can actually say, hey, here's this big hole. Well, it's not on the checklist. We don't have to worry about it. So that's how it can fail. But I've also seen it work. A problem is also with the fast changing. When I was at IBM, we were trying to get something certified by FIPS 140-1 Level 4, which means something. There were power analysis attacks were just being discovered in the open world. And the NIST people and presumably the NSA were trying to figure out, okay, how do we write down a standard for this? Because every week it was changing. How do you say, if you do this, then it's good enough?
Okay.
And so some of the things are very hard to quantify.
You think about, and in a commercial context, you're a retailer, you spent millions of dollars to bring your equipment in every store up to a certain level, and by the time you've spent all that money and it's there, hackers have found a way to get in, and you've got to upgrade all over again. And if you don't do it immediately, you were only using an MD5 hash, you should have been using an SH2 hash. And actually, you know, that was SH2
You didn't
is
salt it
you know,
properly,
right?
yeah.
Yeah, that's exactly right. You can never win, especially in an after the fact situation, because hindsight is perfect.
Is this the kind of thing where you could see a role for the FTC? Because I could see a problem where I could go get a certification, I could go be audited by and you know, there are all of these security companies that are popping up and starting to become big and going public and things like that. And I could have a certificate from one of them, but that's effectively a before the fact expert opinion that turned out to be false when I got hacked. So it's hard to see unless someone is gonna say, you know, someone is gonna bless these certificates, and I could see like the FTC doing that.
Well, I would say not that the certificate was false, it's that hackers are 5 steps ahead of us. And the certificate may have been perfectly accurate, but hackers found a way in anyway. And that is a key sort of education point that we, in dealing with AGs, try to press, AGs in particular. The FTC, you know, with the Wyndham, the whole issue in the Wyndham case is that, and that's our case, where we're saying.
So you can't comment.
Well, no, I can comment on it.
I was gonna ask you.
Yeah, the position in that case is that the FTC really does not have legislative authority to assume for itself the role of setting security standards. It's not been given, and now the current status of that litigation is the Third Circuit didn't accept that view, but the issue is still out there. And I'm thinking if you want someone to issue a certificate, I'm not sure that a government agency is the best entity for that.
Well,
I don't know.
I-
What do you
Timely.
think?
No,
I don't know.
some of the NIST things have worked pretty well for what they can address. But it's just, again, this big problem of, okay, it's great, here are these tests. So there's a nice, you know, reproducible thing. Did you make it or not? But what are the tests covering?
Well, and I think it also.
What's not in the text?
It's context specific too. If I've got names and addresses in my database, do I really need two-factor authentication and a segmented database and file integrity monitoring?
Whereas if you're a health insurance company.
Right. So you've got to really take the sensitivity of the data into account, and you know, a lot of things. And where is it in the network? What is it? Is it all of that kind of stuff? And I would imagine that's true for every company. What I said at the beginning was, we have all this focus on personal information, but companies aren't in the habit of thinking, okay, apart from personal information, what are my crown jewels? What are the key pieces of information that would make a big difference if it got out? And so once I've identified it, then what do I do with it? Do I send it to Newswire services? Do I let my employees take it out on the road in unencrypted laptops? Or on all of that, if you start from that perspective, then you will self-define, I think, the level of security that you need for that most important piece of data.
If we're talking about certification, something else I've seen is where something is subject to 2 different kinds of certification and they're at odds. So a classic example of this is medical equipment. It's got an operating system in it. Quick, let's patch it. Oh, wait a minute, it touches a human. This constitutes a change that invalidates its FDA certification. And that's something people were wrestling with. And you might see some more of this in terms of
Yeah, that's exactly
other
right.
kinds of with cars or transport devices.
You know, you're in a company that deals with agents, and you've got you put this system in place back in 2003, so everybody's using. It's all based on Windows 2003 software, and it's now 2015, and you say, look, we're going to upgrade, and the agents say, well, good for you. You know, you've got $1 bazillion. We're just your agents. We don't have the money to upgrade. Are you going to pay for the upgrading? These are tough things to do.
In terms of identifying what the crown jewels are and protecting those aggressively, is sports an industry that really has highly valuable information these days, or is I guess competitively valuable information, or is the rise of analytics mean that they're kind of all working from the same premises anyway? And so I mean, you know, the Astros were not particularly secretive about sharing the spin rates or the reason they signed different players. That seems like if that's something they've figured out, they might not want to reveal, but if everyone knows it now, maybe there's no real secrets there.
I don't think there's obviously as many secrets so-called as everybody. The benchmark was Moneyball. Moneyball's 13 years old, that
Right.
book. And he never did win, by the way. And, no, he didn't win. And, but the concept of the pitch counts and deep counts and all that stuff, I mean, everybody's operating from pretty much the same general approach. And everyone is subject ultimately to the individual whims of the talent that you did wind up with. Even if you had a model and an ideal, doesn't mean you accomplished the goal of finding the right person. So now you're stuck with this guy, and you got to deal with his foibles. But I just think that the answer, most teams, I just don't think there's hardly any secrets any longer. But there's points of emphasis probably, right? And there's druthers, whatever. Still is going to be that, So, but I just think that we've come a long, long way since Moneyball in the last 13 years in terms of the breadth of information and the embracing of that information by, it's become things that were taken for granted that were unique to the A's then or a couple of teams are now fairly universal. And that's true. But once again, talent, raw talent dictates events a lot. You did note that not everybody swinging at that pitch last night is hitting the ball 452 feet, as Joey Batista did. And,
I wondered how you deal with the situation that there's so much fluidity between teams, that players move between teams all the time.
Players, coaches.
And they learn a lot. In Massachusetts, there was an article yesterday about EMC being taken over by Dell. And they said that could cause a big impact in Massachusetts for non-compete agreements. In California, there are no non-competes. In Massachusetts, they're strictly enforced because companies like EMC really wanted them. Now that EMC isn't on the scene, is that going to cause a change? When you think about that, EMC loses a salesman, they're immediately running to court to try to keep that salesman from working from a competitor. But in baseball, players move back and forth all the time.
They do. Well, that's true. And so this. And of course, the sport that's amusing in this regard is football, because Bill Belichick is one of many coaches who has made a habit over the years of picking up a player was just released by a team recently who happened to be the opponent next week, and having him on the practice squad or having him around for a week and pumping him for whatever information he can get out of him, and then after the game's over, discarding him. I mean, but this is part. No, yeah. This is so. There's an idea. Baseball, that kind of information isn't so precious as they. Once again, football is so puffed up and self-important that, and pompous, and in my judgment, that but that it stands apart in this regard.
Right now, I can't think of how this would apply in sports, but I would be remiss in not saying we've been discussing disclosure of confidential information, and on Security 101, there's also we talk about CIA confidentiality, but also integrity and availability. And I've seen other industries where they're worried about not just, could this get publicized, but, what if our crown jewels get corrupted? They're not there anymore. Or it turns out we've been shipping a product that has this Trojan horse that was put in by a nation state. Or availability. At the crucial time, our bandwidth goes down. So these are just, I guess, things to think about in the context of impact of hacking activity. Illegal hacking would not just be disclosure of information.
Well, I've just gotten the card that tells us we're way over time and we need to move on to.
Is it sudden death now? Is that the
We've got the $1,000 bonus round. So I just want to say a few words at the end to thank, first of all of our wonderful panelists, Mark Szpak, Mandy Petrillo, Sean Smith, and Bob Ryan. Thank you so much. I've really enjoyed having this conversation. I hope that the audience has as well. So thank you.
I applaud you
I'm
guys.
supposed to applaud because
I applaud you guys.
I also want to thank all of the students who helped put this together. First, the board of the Sports and Entertainment Law Society, Amanda Ramirez-Kelmer, Dan Schwartz, Annie Carrick, Andrew Hogan, Chelsea Vanderwood, Brandon McCool, and Alex Walsh, who was on the board last year and came up with the idea for this event. And I know all of them have put in a lot of effort to put this event together in the last few weeks, so thank you to all of them. Finally, I want to thank my colleagues, Alex Roberts, Mike McCann, Mary O'Malley, AJ Kierstead for helping organize, helping deal with the logistics. And I know I've enjoyed it, so I want to thank all of you for coming. And I hope you'll be able to join us outside. We've got drinks and hors d'oeuvres set up. And but before you do that, thank you one last time to the panel. I know I've really enjoyed it, so thanks everyone.
Anybody ever tell you have a great radio?